Hello everybody. Today we're going to talk a little bit about jurisdiction and the court's ability to restrict the way it behaves. So the first thing we're going to talk about is the definition of jurisdiction, which is basically the authority of the court to make a decision on a matter. Now, as you know, the courts only have the powers granted to them by Congress and the Constitution, so they can't do anything beyond that power granted. So that concept of staying within that circle of granted power is jurisdiction. Now, when I was in law school, we spent weeks talking about jurisdiction, and it was very painful and dry. And fortunately for you, you don't need to know all that much about jurisdiction. I think the book does a good job of telling you what you need to know about this concept. So we're not going to spend a whole lot more time talking about it, fortunately, because I think there's some more interesting things that we talked about in Chapter 3, and that is really the concepts of judicial restraint, and we're going to focus on a couple of those ideas because I thought those were a little more interesting. The first idea of judicial restraint that I want to talk about is the concept of standing. And what standing gets down to is that somebody has the right to sue because something happened to them. And I'm going to start off with this concept about the failure to state a claim upon which relief can be granted. When we study civil procedures later on in the quarter, you'll learn about the ability to dismiss a case before it even gets very far, really right at the beginning. A lawyer can make a motion to dismiss a case because the plaintiff of the case is asking for something that just can't happen. They're asking for something upon which relief cannot be granted. And these areas of judicial restraint that we're talking about are some of the areas where the court could say, yeah, because this is missing, we can't grant relief. So one of those things that could be missing is standing, the right of somebody to sue because something happened to them. Let's say I saw my neighbor get swindled, and I thought, I want to sue that person because they treated my neighbor so badly, and it's clear that she suffered from the intentional infliction of emotional distress. So I want to go and I want to sue that guy. So I go to court, I file an action for the intentional infliction of emotional distress against my neighbor. Well, the court would just throw that out because nothing happened to me, really. I might be offended by the fact that something bad happened to my neighbor, but since nothing actually happened to me, I would lack standing to sue. So the attorney for the mean person would say, sorry, we want to file a motion to dismiss because I've failed to state a claim upon which relief can be granted. So I need something, in order to have standing, something needs to have happened to me in particular. I need to have suffered some sort of harm which can be remedied by the court. Now, as you may have seen in my biography, when I was practicing law, the area of law I practiced was environmental law, and this issue of standing comes up a lot in environmental law because sometimes the one suffering the harm is not a person. There was an interesting essay back, I think it was in the 60s, about whether trees had standing. You know, who can sue on behalf of the harm that is happening to the environment? And if there is nobody who has that standing, can harm continue to happen to the environment sort of unfettered? Because who has the right to go before the court and ask that that harm stop? And what the courts eventually decided was that if somebody could show that they engaged in the environment fairly extensively, like maybe they went hiking all the time in a particular area and had since they were a child, and when all the trees got cut down, they were personally harmed because they were no longer able to get the kind of enjoyment that they used to get when they went hiking along these trails, well, then they could sort of establish that they had standing to sue in a case like that. But it's very difficult to establish standing in cases like that, and it comes up a lot in environmental law. So that is the idea of standing, and we're going to wrap up this first part of the lecture, and we'll come back and talk about mootness.